Suzanne Bechtel here again with more on Chapter 3. This is the second of a 5-part lecture series on ethics and malpractice. Chapter 3 from the Practical Law Office Management book by Cynthia Traina-Donis. We're going to cover in this lecture Unauthorized Practice of Law, also called UPL. Some people also call it Unlicensed Practice of Law, which I think is a good term for understanding what we're really talking about here, is that it's unauthorized means unlicensed, but just another way of looking at it. And of course, I'm sure you have all had opportunities to deal with UPL issues and in terms of your knowledge and understanding from other classes, but this just can't be emphasized enough, because practicing law in Florida or holding yourself out to be a lawyer when you're not in Florida is a 4th-degree felony. So we like to make sure we give you plenty of information about UPL. The main objective for this one is the unauthorized practice of law. The first one listing the factors that are used to determine whether a paralegal is quote-unquote practicing law. This is a great little chart. Nearly every state has criminal statutes that prevent non-lawyers from practicing law. And these laws may place criminal sanctions on non-lawyers, including paralegals, who are found to be practicing law. Often, to learn what a paralegal cannot do, we look to the common duties of lawyers. Because if they're common duties of lawyers, we have to evaluate whether they are the types of duties that a paralegal should do. If they resemble practicing law, then you need a license to do it. The big ones are giving legal advice, representing clients in court, performing legal analysis, and preparing legal documents. And I would qualify that the performance of legal analysis, it is an attorney role. However, I want to add that legal analysis is a common paralegal task, such as when you're doing legal research. However, it's when a non-lawyer communicates the advice, the legal advice, to a client, that I dub it the practice of law. And that communication can be either verbal or in writing. So it's important to think carefully before signing letters written to clients. If there's legal advice in that letter, don't sign it. Set it up for the attorney to sign. Other things that can be the practice of law is evaluating a case and selecting an appropriate course of action. And again, paralegals will help to do this, but the ultimate decision maker is the lawyer, and the paralegal should never communicate what appropriate course of action is to a client, either in writing or verbally. Accepting or rejecting a case, that is the practice of law, because inevitably the accepting or rejecting a case requires legal analysis. And that's why lawyers do the initial consultation, not paralegals. And that's just one example. Setting a fee. In other words, client wants to hire the firm. The fees should be discussed by the attorney only. I have a little bit of a little degree of uncertainty about giving a client on the phone, a potential client on the phone, a range of something that's very standard in the law office that you're working in. However, this book does profess that you shouldn't even do that. But I think another slide coming up, we're going to go into that, and I'll give you my 2 cents because I like doing that. Sharing a fee with an attorney. So, or vice versa, an attorney with a paralegal. Sharing a fee, attorneys can bonus paralegals, but if an attorney takes a fee and then says, I'm going to, makes arrangements ahead of time to say, I'm going to share all the fees I get with you, paralegal, non-lawyer, we're not going to, that is not allowable, because that is resembling an attorney. You resemble an attorney when you take a fee and you put that fee in your pocket. They have another list on the right here of other work in a law office. All of these things in the right-hand column are things that are duties that a paralegal would really typically not worry about having a problem with practicing law with them. It's when that information gets communicated to clients and you explain, go a little bit too far in your explanation. I mean, for example, if you were preparing correspondence, preparing drafts of pleadings, you would not sign those documents. If you were, and correspondence that contains a legal opinion would not be signed by a non-lawyer. Communicating information at the top of the list, the second one. Information, not advice. Communicating information, I repeat, not advice to the client. So these are some areas that a paralegal can definitely do, those on the right. On the left, however, those start looking like lawyer work. Courts look at unauthorized practice of law claims, and then when they get those claims, it's when somebody's been harmed by a non-lawyer, and they filed a complaint with the Florida bar. So the court's going to look at from their perspective, which is asking the questions: have you represented a client in court? Has a paralegal prepared legal documents without being supervised by a licensed, underline that, a licensed attorney? Or has the paralegal given legal advice to a client? Did the paralegal accept a client case, reject a case, or select a course of action alone by himself? Did the paralegal set the fee for handling the client's case? Is the activity one of the traditionally performed by lawyers? Those are on that left-hand column in the previous slide. And has the paralegal misrepresented his or her status as a non-lawyer? Misrepresentation happens impliedly and explicitly. So explicit misrepresentation would look like this. Paralegal walks in the room and says, "Hi, I'm Suzanne Bechtel. I'm here to help you with your case." I'm your lawyer. That would be misrepresentation, explicit misrepresentation. I've claimed I'm a lawyer when I'm not, and so I've misrepresented the person, myself to the person, the client. There's also implied misrepresentation, and that's when there's silence. When you introduce yourself and never tell the client that you are a paralegal, not a lawyer, thus can't practice law. Implied misrepresentation can also happen over time. Clients may not remember that first time that you said you're not a lawyer. So a client may over time forget that or not realize really the difference. People don't. There's a survey that Florida Bar did several years ago that like 70% of the folks surveyed in Florida thought that paralegals had a license to practice law. So it's about not just being explicit in your appropriate representation as being a non-lawyer, but not being explicit in terms of calling yourself a lawyer. So how do you avoid unauthorized practice of law? It's really quite simple. Be supervised. If you're not getting supervised by an attorney, and if it's in your work, if the attorney is not supervising you, you're not working in the right place. That's a time to leave, because you're getting set up for a problem. And like I said, possibly a felony. Never let a client talk you into giving the client legal advice. This happens all the time, and you're really good at what you do, and you like to help. Most paralegals are in the job. One of the reasons why is they like to help others. But helping can go too far, and the client will know this about you. Oh, Suzanne loves to help people. Help me out. I'm going to call Suzanne and ask Suzanne, "Hey, Suzanne, do you think I have a good case?" I'm not going to answer that. That's a legal opinion. I think in family law, I probably ran into this area where clients really wanted me to answer their question that involved legal advice. Family law work was like that for me because the client always wanted me to tell them, what do I do? What Monday mornings, okay? Monday mornings were a lot of visitation. Child sharing, they call it now in Florida, takes place with a parent, and there's some bad animosity between the parents, and the client calls up and says, parent A did this, did that, did this. I want to know what I should do. Should I call the police? Should I call Child Protective Services? Those are things that you need to take to the attorney. Your attorney will know how to advise the client if that kind of thing happens. It also says don't start sentences with words like you should or I think, because that implies that what your information you're giving them is legal advice. I mean, I think you got to look at context too. If a client calls me, and I'll go back to the dissolution of marriage, the divorce family law firm, you should. Well, maybe the client is having trouble finding some information that they need to answer interrogatories or a financial affidavit. Well, you might say you should go to your bank and ask the bank to help you. But when you direct a client into you should call the police because, mother's calling you or father's calling you on Monday morning in the example I gave earlier, that's going to look like legal advice. And the client's going to think you're giving them advice. And they're going to do what you ask them to do or should them to do or think them to do. I think this is a case of child abuse. You should do this. It happens all the time in family law. And always, as I pointed out earlier, don't let go. Don't think because you told a client once that you're not a lawyer that you should stop telling them that you're not a lawyer. That's it. Simple rule. Next, other tips. Don't set fees in a case by yourself. Going back to that topic I mentioned earlier in the slide with the two columns, where lawyer work versus other work. I worked for bankruptcy lawyers, family law lawyers. I'm trying to think of lawyers that did wills, trusts, and estates. And the phone calls come and a paralegal gets them, and especially in a little firm, you end up answering the phone a whole lot. And the clients and the potential client is saying, I need a simple will. This is classic. I need a simple will. How much will it cost? And, the lawyer has already told me what to answer. All right? I've already asked the lawyer. If the lawyer didn't tell me, I'm going to ask the lawyer, what do you want me to tell potential clients that make a phone call here and think they want to file bankruptcy or get a simple will done or something? What do you want me to tell them? Lawyers always explain to me that let them know that this was a long time ago. A Chapter 7 bankruptcy starts at $600, and that there are a lot more now. Or a simple will starts at $150. That was a long time ago too. But I always qualified that with, this is not a fee setting. I'm not setting the fees. I'm telling you now where the prices begin. And when you come in for your consultation with attorney A or B, he or she's going to go through your factual circumstances and then tell you what your fee would be you would make a decision then. So it's important to massage that conversation, make it clear that you're not an attorney, that you're not supposed to set fees, that you've been given permission to tell potential clients that it starts at this amount, but you need to come in for a consultation to know how much this is going to cost you. Never accept a case by yourself. So never have if people come in the door, and I've worked for so many little tiny law firms where, someone just shows up. Hi there, I want to see if I can get a Chapter 7 bankruptcy done. Can you help me with that? And the last thing I would want to do is say, oh, come on back. Let's sit down in my office and try to figure out, what price range you fall into and what kind of facts belong to your case, etc. It's one thing I've gathered information for lawyers. Lawyers get late coming in, client can't wait any longer. Let me ask some questions, take an interview down, and give the information to the lawyer later. But never, ever, ever would I ever accept the case by myself. In other words, I would never hand the client a fee agreement and say, here, We'll get started as soon as you fill out this form and bring it back to us and bring your fees with you, blah, blah, blah. None of that kind of conversation should be had with a client and a paralegal. Get the facts. If your lawyer has no problem with that, your lawyer's going to need to trust you to do that. So be careful. Don't make your lawyer upset. Don't scare your lawyer. And never appear in court to represent a client before a court. And you probably learned in other classes, but if you haven't already, there are some rules specifically carving out opportunities for non-lawyers to represent people in court. My best example is Social Security disability. I have I'll call her my ex-stepsister because I've pretty much parted ways with her. Well, no, I have fully parted ways with her. But she had a disability claim, and she had a lawyer that fired her, and they had good reason. She didn't have a claim until she got Baker Acted. And once she got Baker Acted, no problem. I went in and I went to court with her. But I'm telling you what, it takes a lot of skill. It was much more than I ever thought it would be. So I probably will never, ever step up to the plate to do anything like that again without more training. All right. So that concludes the unauthorized practice of law. I hope the advice, and of course it wasn't legal advice, I hope the information that you got there was helpful. I hope the examples were useful to you. If you're not working in the law office, I think that it's a fearful area, the unauthorized practice of law. They drilled it into me when I was in paralegal school years ago, 35 years ago. I was in paralegal school. And they told me, don't do it, don't do it. And when I first went into the law firms, I was extremely conservative. Even some of the ideas I've given you here, I wouldn't even dream of doing. For example, tell the client the fees start at $600, or tell the client, I was so scared of UPL that I was more conservative than I would be today. And those examples I gave you are less conservative examples. But it's about, first, make sure you have a trusting relationship with your attorney. Make sure you're being supervised. Do excellent work so your attorney can trust you. And know that you're telling people what he or she wants you to tell them when it comes to questions. And setting, or I should say, quoting possible fees. Ask questions. Make sure what you're doing is what your attorney wants you to do. And if your attorney ever wants you to practice law, just don't do it. And one of those ways is the implied way, by not being the attorney not coming to work very much, just not supervising. Some things that can come in the way of supervision are attorney is over obligated, attorney is ill, seriously ill, attorney is having some substance abuse problems, attorney is preoccupied with his or her own life and not managing the office, letting you handle everything. That is a bad place to be. All right? Thank you.